Actually, there are a lot of chapters that are important, but starting right from the beginning, chapter 1 and 2 on license laws, rules, and regulations is very, very important. As a matter of fact, it might be the most important two chapters on the course. So let's start from chapters 1. When you get a test question, what's the purpose in chapter 1 of the license laws? The answer that they're looking for is to protect the general public. So the license laws, rules, and regulations, when you get a test questions, the question they're going to say, what's the purpose? The answer is to protect the general public. You're going to get a question, what constitutes engaging in the real estate industry? And the answer to that is any single act. Now, license laws were not enacted until 1921 in the state of New Jersey. Okay? And of course, all states now have license laws. You want to remember in chapter 1 that there are 8 individuals that sit on the New Jersey Real Estate Commission. And of the 8, 5 of them are real estate brokers. And they have to be real estate brokers for 10 years and residents of the state of New Jersey for 10 years. 2 come from the public sector, and 1 of the 8 is a governmental designee. So what you have then are 8 individuals that sit on a real estate commission. Of the 8, 5 are brokers, okay? 2 come from the public sector, like they could be architects, engineers, computer people, okay? And 1 of the 8 is a governmental designee. They all that's the 8, okay? They all serve 3-year terms, except the governmental designee, who serves at the pleasure of the governor and can be replaced by a new governor. 8 individuals, right, sit on the New Jersey Real Estate Commission. Of the 8, 5 are brokers, 10 years as residents, 10 years as brokers. 2 of the 8 come from the public sector, and 1 of the 8, they all serve 3-year terms, except the governmental designee, who serves at the pleasure of the governor, can be replaced by a new governor. Okay. Question then is, who is a broker? Who is a broker salesperson, and who's a salesperson? A salesperson is an individual in New Jersey that is 18 years old or older, has a high school education, has attended a 75-hour course of study in an approved school, has taken a state examination, has passed, and gets fingerprinted, has an employing broker, and is of good moral character. That individual is a real estate salesperson in the state of New Jersey. Let's talk about a broker, another level of licensing. A real estate broker is an individual who has had 3 years full-time experience as a salesperson in New Jersey, and when you get a test question, full-time is what approximates from 10 o'clock in the morning till 8 o'clock in the evening, 5 days of any week. That's full-time. You don't punch a clock, but that your broker's going to have to attest to that later if you want to become a broker, okay? This individual goes to broker school. He's got 3 years full-time. He can work part-time, by the way, also. Wants to be a barmaid, a bartender, cut hair, that's okay. But it can't exceed 25 hours a week. And I'm talking about somebody who someday wants to be a real estate broker. If a person just wants to stay as a salesperson, there is no limitation. And if the broker doesn't complain, that's fine. You sell 1 house a year and be happy. But if an individual wants to someday be a broker, then there are rigid requirements. 3 years apprenticeship, 3 years full-time, a certain amount of activity, certain amount of sales, leases, certain amount of listings sold, maybe a little commercial, to show the real estate commission that the person not only had a license for 3 years, but did something about it, okay? Because see, a form is going to be filled out by anyone who wants to be a broker, by the brokers they work for, and the broker is going to have to fill out with a sheet of paper what that salesperson did. Was he working full-time, part-time, how many houses they sold? And then that form goes back to the Real Estate Commission, and they send the salesperson a memo, the Real Estate Commission. Your experience fits our requirements, you can register to take the course. Now that person then goes and takes a 150-hour course right now in the state of New Jersey, which could change. Okay, in every state they have different requirements. In New Jersey right now it's 150 hours, where salesperson 75, they take 150. That individual takes a state exam, and if that individual passes, he or she gets fingerprinted, fills out the forms, tells the Real Estate Commission the name of their agency if they want to open up, and what checking accounts. They have to have a general account and a trust account. It has to be in an approved bank in the state of New Jersey, and they get, like I say, they get fingerprinted, but then they can open up an office, and they're in bid. That's it. That's a real estate broker. So the difference primarily between a salesperson in New Jersey and a broker is that a salesperson cannot hire other salespeople. A salesperson cannot have a formal office, and a salesperson cannot charge the public for his or her services. Only a broker can do that. That's the main difference between a broker and a salesperson. Now, let's talk about the next level of licensee, broker, salesperson. I happen to be a broker. Now, if tomorrow I got burned out, or I can't pay my rent or my fixed expenses, and I went across the street to a friend who's also a real estate broker, I said, look, I'm closing my office. Would you have any problem with my joining your agency? If he says it's okay, my license will be changed on a computer from broker to broker salesperson. Every agency can only have one broker of record, but there can be many other brokers affiliated with that agency. So there's going to be one license issued in the name of a broker. He or she is the top person, or owns the agency, or is the person named in the corporation license. But there may be many other brokers affiliated with that agency. Well, those other brokers' licenses are not going to read broker. They're going to read broker salesperson. One license reads broker. So what we talked about then, very briefly, is the levels of licensees: salesperson, broker, and broker salesperson in New Jersey. Now, who needs a real estate license? Well, anyone who lists real estate for sale, anyone who sells real estate, anyone who sells real estate at auction, who does property management, sells lots, anyone who does rentals, anyone who sells business opportunities, if it involves a lease or the building, which most do, needs a real estate license. Okay. Bottom line is, if money is involved, pretty much a license is necessary. Now, not everyone in New Jersey requires a real estate license. For example, there are exceptions or exemptions of individuals that do not require a license. An attorney gets an exemption if he does real estate as an incidental part of his law practice. He's exempt. A homeowner selling their own real estate, they're exempt. A landlord renting his or her own real estate is exempt. No license is necessary. A bank is exempt. Insurance companies are exempt. A receiver is exempt. A receiver in New Jersey is a person appointed by the state of New Jersey to handle the affairs of somebody who has gone bankrupt. They need to have somebody sell the assets of the person going bankrupt. That person is referred to as a receiver. Also is exempt. Now, you have to be a little careful in a test question where they may say, for example, does the John Hancock Life Insurance Company need a real estate license to sell real estate? The answer is no. The company, no. But the agents that sell life insurance for John Hancock, they want to sell life insurance during the week, and on the weekends they want to sell houses. They have to go to class and get their license also. So there's a difference between a company being exempt and an agent being exempt. The agent is not exempt. An insurance broker is not exempt. Has to go to class, take the course, take the state test. But the company itself does not have to do that. A bank doesn't have to have a special license because they're exempt. An executor, somebody who has a will, names somebody to take care of their affairs, they don't need a license. Any trustee is exempt. An administrator is exempt. Okay, so we talked about who needs a license. and activities covered by people who need a license. Then we just spoke about those that are exempt from needing a license. Payment for services to an agent can only come by his or her licensed real estate broker. A salesperson cannot get money from another salesperson, from the public directly. They have to only, the IRS wants all money to come out of the broker's account. The IRS requires all money goes out of the broker's account. Now sometimes a broker hires assistants because their money is really, they earn their due by meeting people. And not that paperwork is not necessary, it is. And bookkeeping is certainly necessary. Or putting for sale signs on the lawn are necessary. But quite frankly, that's beyond the scope of what a broker is paid for. He wants to concentrate on managing other salespeople in the office, on meeting new people to do business with. So what a broker does sometimes is he hires assistants. He gets a high school student, a college student, pays them a couple of dollars, whatever. It's cheaper. He nets more at the end of the year doing that than he himself doing menial tasks, which are important to the agency. Now, an unlicensed assistant is only allowed to do a certain amount of tasks. For example, an unlicensed assistant in a real estate office for a broker or for a heavy hitter, $1 million producers hire them also, cannot answer the phone and give information about listings. They cannot, for example, host open houses. That's not permitted, okay? They are restricted on what they can do and what they can't. Again, they can't answer questions about listed property. They can't discuss or explain a contract. Now, an unlicensed assistant can answer the telephones. They can do bookkeeping. They can set appointments for agents in the office. They can keep records. They can follow up on loan applications and compute commission checks. So there's things that a licensed assistant can do and things she cannot do. And a lot of it's common sense. Okay. There's a time limit on application. For example, in New Jersey, an individual must take the state exam and have a broker within 1 year of completing the real estate formal course of study. 1 year from the course ending. Okay. Corporations can be licensed provided one of the officers of the corporation is a licensed real estate broker. Okay. So the individuals get together and they say at our last meeting in our minutes we named Frank Felice the broker of record for our corporation. We also gave him 1 share of non-voting stock, and we also appointed him the secretary treasurer of our corporation. And that's what the Real Estate Commission wants to see in order for a corporation to be licensed. They want to see that in the minutes a real estate agency was formed by individuals or an individual. They want to see who the broker of record is, and it has to be 1 broker of record of the corporation, and that broker of record has to have 1 share of non-voting stock and be appointed one of the officers, and then the corporation can be licensed. So in the corporation license, it would read ABC Realty Corporation, and underneath that, Frank Felice, if it was me, broker of record. That's the way the license would read. Now, sometimes a broker either dies or becomes mentally incompetent in an agency. It happens. When that occurs, in New Jersey, the widow or widowers are allowed to appoint what they call a temporary broker of record. Now, this temporary broker of record has to be either a broker or it could be a salesperson who has 3 years or more full-time experience. Okay, that broker of record has to have 3 years full-time experience. That individual then has to go to broker school, the temporary broker, and get his or her real estate license within 1 year of the death of the broker with no extensions. And when you get a test question, just remember that all licenses in that agency, when the broker dies or becomes incompetent, become suspended. Now, they didn't do anything wrong, but they also don't have a broker of record to work for. And in order to be licensed, you require a broker of record. So again, when the broker dies or becomes incompetent, the New Jersey Real Estate Commission permits a temporary broker of record to be installed. That temporary broker has to be appointed within 30 days of the death of the broker and has to go to broker school and get his or her broker's license all within a year. And once the broker dies or becomes incapacitated, all licenses, the salesperson's licenses, are temporarily suspended. In New Jersey, there is a guarantee fund. The guarantee fund is established to protect the public against unscrupulous salespersons and brokers. The public has 6 years to go against this guarantee fund. Okay, and they can, if they do everything that they're supposed to, they can collect up to $20,000 from this guarantee fund. But they have to first take the salesperson or broker to court, civil court. They have to name the New Jersey Real Estate Commission as part of the lawsuit. They simultaneously have to go to the Attorney General's office and file a criminal complaint against the salesperson or broker. They have to win in court, get a judgment against the salesperson or broker, and prove they cannot collect. Now, if they take all those steps and they can't collect because the salesperson or broker may have gone bankrupt, or they could have moved to another state, when they've done all these things, including getting a judgment against them, then they can fill out an application and collect in New Jersey up to $20,000 from the guarantee fund. And when you get a test question about that, and another test question, they're going to say, who funds the guarantee fund? Who actually is the individual, or how does the individual fund it? The answer is through, or I apologize again, they're going to say, how is it funded, the guarantee fund? The answer they're looking for is through first-time licensees that contribute to it. So when a first-time licensee pays the broker a sum of money, right now it's $160. It's for an application fee, it's for a 2-year license, and some of that money goes into the guarantee fund. Okay, it's maintained. The guarantee fund is again maintained by the state treasurer in the state of New Jersey, and a salesperson or a broker, one of the conditions of ever getting their license back, if it's ever been suspended or revoked, is full restitution to this guarantee fund plus interest. That's one of the automatic conditions of the guarantee fund. It's administered by the Real Estate Commission, and it's maintained by the state treasurer. It's maintained by the state treasurer, the guarantee fund, which could be a test question, and administered by the Real Estate Commission. I'm going to just, there is a Land Sale Full Disclosure Act in the state of New Jersey. It has to do with New Jersey residents purchasing real estate land outside of the state of New Jersey. Years ago, New Jersey residents got ripped off by purchasing real estate outside of New Jersey, so the Real Estate Commission has a Land Sale Full Disclosure Act. It's a federal law and a state law, and there's several changes of the certain precautions because of that law. For example, if residents of New Jersey purchase out-of-state land, they're given a 7-day right of rescission instead of the normal 3 days. Also, the new company would have to have a New Jersey broker of record as part of the registration. Also, they have to give the public the APR if there's any financing involved. They have to do an annual report to the New Jersey Real Estate Commission. And a standard test question about the Land Sale Full Disclosure Act is the 7-day right of rescission, and also they'll probably ask who maintains it or who administers to it. And the answer they're looking for is the Bureau of Subdivided Land Controls. So I'm taking a look at some of the key terms in front of this chapter, and I want to make sure that we touched on them, and maybe I didn't, and if I didn't, I'll go back over them, but I think that I might have covered it. I'm taking a look at some of your key terms. A broker we're all familiar with. We talked about a broker salesperson. I'm talking right in the first page in front of your chapter 1. Okay? First page in front of your chapter 1. Okay? I'll give you a minute to get to that page. Just take your time. Okay? There you go. Now you have the key terms, right? So we know now who a broker is. Okay? We all know who a broker salesperson is, correct?
Yes.
And the Bureau of Subdivided Land Controls is what I just mentioned. They maintain the guarantee fund. I'm going to just relax and I'm going to sit down. And okay. We just mentioned what a guarantee fund is, and just remember, the easy way to remember about a guarantee fund is for goodwill, to to give payment to the public when they get hurt by an unscrupulous salesperson or broker. New Jersey Real Estate Commission, we said, had 8 individuals that are members, 5 brokers, 2 come from the public sector, 1 a governmental designee. Forget pocket card identification. That was years ago, up until, well, I shouldn't say that, up until very recently, a year ago, to save money on paper work. There is no more pocket card. Brokers print out a pocket card for identification for their salespeople. So there is, anything that reads about the pocket card is outdated. It's done by computer. The New Jersey Real Estate Licensing Act is sometimes referred to as Title 45, Chapter 15. The Real Estate License Act is referred to as Title 4, and it's set up by the Commission, and the rules and regulations are set forth by Title 11, Chapter 5. It looks like, oh, okay, in the second column here, real estate's a realtor. A realtor is an individual who's a real estate broker who subscribes to a high code of ethics. He pays the fees, and he's a realtor, okay? So salespersons are realtor associates if they choose to. Now, realtor is just a trade name for individuals who are in the real estate industry who choose to join a trade group. And the NAR, the National Association of Realtors, has over, I think, 1 million members right now of real estate people who want to join an association. And one of the reasons, of course, is to be associated with a group of people like themselves into a trade group. The other reason a broker generally voluntarily joins and becomes a realtor, and in order to do so, again, he or she has to subscribe to a high code of ethics and pay the fees. Now, in order to join a multiple listing service, a broker in New Jersey or in our area has to be a realtor. So brokers really don't have too much of a choice about being a realtor. They're almost obligated. I mean, legally and technically they don't have to, because there are brokers out there that are not members of the multiple. So they don't have to join a multiple, and they don't have to be realtors. So it's not to be confused. All realtors are brokers, but all brokers do not have to be realtors. Okay. Now, salespersons are officially known as realtor associates, although the public lumps everybody together and says my realtor this and my realtor that, but in point of fact, that's the way it works out. A referral fee. Brokers can get a referral fee from another broker from another state. Salespersons can't get any money directly from that broker. Everything has to pass through your present broker, and then he pays you. I want to go on to chapter, it looks like chapter 2, which is really a continuation of chapter 1. Real estate brokers have to have a real estate office. That's the law. Now, a real estate broker can have an office in his own house, but he cannot have an office in the house of his salesperson or broker salesperson. Okay. All real estate brokers have to have 2 checking accounts. One is called his general account, and the other his trust account. When you get a question about the trust account, remember that it's sometimes referred to as an escrow account. So trust account and escrow account are one and the same. Now, from the general account, the broker pays all operating expenses, pays his office expense, pays commissions to his salespeople, pays advertising costs from the general account. And I might add another thing. When a new broker goes into business, the New Jersey Real Estate Commission sends him or her instructions, and one of them is that he has to put his money in an approved bank in New Jersey. And the reason for that is all banks are not approved for $250,000 by the FDIC. So there's a list of banks only that he can use. Real Estate Commission at all times has to know the banks that the broker has his money in. When he changes banks, the broker has to notify the Real Estate Commission, same as an address change. Now let's talk about this so-called trust account, or I guess we'll label it a trust account. Now, the trust account, there are several requirements in the trust account for the broker. For example, it's generally kept in a non-interest-bearing account. And yet, if the public insists on interest on their deposit money when they wish to purchase real estate, then the broker has access or has ability to put that money in a special interest-bearing account with the local bank, or give the money to an attorney who has an interest-bearing account. So it's okay, but most of the time, from time of deposit to the time of closing, it's such a brief period of time that the public really doesn't balk at that, to have their money put in an interest-bearing account with regards to the purchase of a single-family home. It goes so fast from deposit to closing, it's not that much interest involved. But some people with commercial real estate or investment real estate put a large down payment. It might take 8 months to close because of the DEP and all the other regulations. They're going to want interest on that $100,000 that's held. Well, then the broker can have access or have the attorney do it. Anyway, this trust account has to be reconciled no less than once every 90 days. The broker cannot commingle the money in the trust account. He can't mix it with money that belongs in his general account. That has to be kept separate and apart. So the broker it's put in a non-interest account. It has to be reconciled no less than once every 90 days. He has to keep the monies separate between personal money or general account money and trust account money. And what else does he have to do? He has to deposit the money into his trust account promptly. Now, when you get a test question, what does promptly mean? It means no more than 5 business days. Business days are different than calendar days. Business days do not include Saturdays, Sundays, and holidays. Calendar days do include Saturdays, Sundays, and holidays. So the trust account has to be put in a business account within 5 business days. And salespeople, when they get a deposit, have to give the money to the broker in a very prompt way within 5 business days so he can put it in his trust account. As long as I mentioned about brokers and salespeople, all offers have to be presented to the seller within 24 hours. Any written offers, not verbal. Verbal does not count in real estate. All written offers there's an obligation of a licensee to present it promptly. When you get a test question as to what promptly means, it's within 24 hours. Now the reason for that is, if it's not promptly submitted to the seller, the buyers can go off and buy something else somewhere else, and when the seller finds out that there was a deposit but it never was given to them, they're going to get very angry and ticked off at that salesperson. That's the reason for the 24 hours. Let's see. I think that the trust account and the escrow, such money, 5 business days, no commingling. Okay, I think that, one other area of the trust account. There was a time in my past as a broker where the money that I had in my trust account was equal to my commission. And the attorneys or the buyers and sellers said it was okay for me to take the money from my trust account to pay myself. Now that's highly unusual. That normally doesn't happen. Brokers give the deposit money to the attorney, and he or the trust, the attorney or the, and then the attorney, the closing attorney, gives out the commission check. But in this instance, it happened to me once in all the years, where my commission was equal to what I was holding in my trust account, and the attorneys said I should make a check to myself from the trust account. And when that occurs, the broker has to take the money out of his trust account and move it to his general account within 5 business days. Otherwise, that's commingling. In other words, the money doesn't no longer belong in the trust account. It's not as serious of an offense as the other way around. If he has money in his general account that belongs in his trust account, that's a real disciplined situation. But the other is wrong, but not nearly as bad. Now, when that occurred, in my case, I asked for a letter also to put in my files in case I got investigated by the real estate commission. They're going to ask for different information about contracts and my trust account. And I got a letter from the paralegal and from the attorney saying this is to authorize Frank Felice to take the money on this deal, on this transaction, to pay himself because it's his commission. That's okay then. Now, as long as the trust account, one last thing is that there has to be zero money in the broker's trust account if he has no transactions in there. So he can have a little bit of his own money in the trust account if the bank he uses requires it. So I happen to use a bank that requires a minimum deposit. So if I got investigated, that would not be commingling. That money, as long as I can mention that it's the bank's requirement that I have that money in my trust account I'm not going to be in any, I'm not going to have any difficulty with the New Jersey real estate investigators. All, any cash deposits given to a broker or salesperson have to be reported on a special form to the IRS, $10,000 or more. There's an advance fee sometimes given to a broker. Now, let's say a builder is unhappy because there's not enough advertising for his development of homes, and he says to the broker, look, we got to do a little bit better, and the broker says, I got a budget, and I have a schedule, and I allot so much money for every listing I have. I've already allotted. Well, the builder, let's say, says to the broker, look, I have to move my houses, so I'm going to give you $10,000 or $5,000, $10,000 as an advance fee, and you could do with anything you feel that's necessary in my behalf to sell my homes in this development. When that occurs, if the amount of money given to the broker is $25 or more, he has 90 days, 3 months, to report back to his principal as to what he or she did with the money. Okay, so he gets it, he puts it in his trust account, and then he moves it over to the general account. For example, he might put billboard signs out on a highway. He might advertise that development of homes in the magazine section of the New York Times. There may be special magazines. There's different things that he can do. So he has to send a report or an email to his principal saying, you gave me $5,000. He has to do this within 90 days, okay? If it's over 25, I'll say, I did this with the money, and give him an accounting, okay? As long as I mention the word accounting, real estate salespersons are entitled to their commission on their transactions within 10 days, not business days, 10 days, calendar days, of the receipt of the commission by his or her broker. That's another reason why salespeople go to the closing. They go for goodwill to make sure everything goes okay. They also go because they know that by giving the check to their agency, to their broker has to pay them within 10 days. Okay. Now, another period of days is in accounting. Some salespeople do deals or transactions, and then before the closing takes place, they have a falling out with their present broker, and they go across the street to a new broker. When that occurs, they will get paid, okay? And the broker is entitled to deduct a certain amount of money they have coming to them because they're no longer at that same agency to take care of the transaction right to the end. Later we'll talk about the report that has to be signed by the broker and given to independent contractor form signed by the salespeople and the brokers. And addendum B says how much the broker can deduct if the salesperson moves to a competitor office before his deals close. So a deal is done and contract signed in August. The salesperson leaves and goes to another agency in September, and the closing doesn't take place till October. Well, when it closes in October, that salesperson is going to get paid for the transaction in September, but the broker can deduct some money because that salesperson is no longer in the office. So it's 10 days to get the money, and the broker has to give a report about what I'm talking about to the salesperson as to how much money they have coming to them within 30 days of their leaving their agency. That report mentions you have left my employ on such a date. You have the following money coming to you: the sale of this, blah blah blah, and the amount of money, the rental of that, so much, and then it gives 30 days for the salesperson to call the broker and say, look, you didn't give me enough on this transaction. And they go back and forth communication-wise. New Jersey Real Estate Commission does not have enough of investigators to go around for complaints between salespersons and brokers, so they don't get involved. Now, years ago, a salesperson could not sue his broker, but today he can. He can take his broker to civil court. And the New Jersey Real Estate does not get involved at all, except when it comes to money. They do protect salespersons. For example, if the salesperson did not get the letter that I just finished talking about within 30 days, then the New Jersey Real Estate Commission will get involved and ask the broker, where is the document that mentions so much? And if he doesn't have proof that he sent it, he's going to have a problem on his hands. So the Real Estate Commission gets involved to protect the salespeople when it comes to that 30-day report. The listing broker, and this, well, we'll chat about that with agency a little later on. Real Estate Commission wants in New Jersey brokers to cooperate with one another, because that's the law. I mean, a real estate broker has a for sale sign on the lawn, and somebody else, some other office asks about it, and that broker says it's an office exclusive. That sounds okay, but they could be hurting the buyer to buy that house. They could be hurting the seller for selling that house if they don't cooperate with that other office. However, having said that, there are times when a seller will say to a listing broker, I had a very bad experience with individuals on a multiple listing service that you belong to. Therefore, I do not want anybody except your office handling my sale. Is that legal? Yes, that's okay. However, they have to sign a waiver of broker participation form. And there is a standard form that the sellers sign attesting to the fact that they only want one broker to sell the house. Then it's okay. Then it's what they call an office exclusive. And that listing broker, when other brokers wish to see that listing, will say, send your prospect over to me. If they purchase the home, you register with me, we'll give you a referral commission. Also, the seller may be a relative of the broker and say, look, I'm not that highly motivated. Why should you be cooperating with other brokers? I just want you to sell it. So it's not so cut and dry that everybody is going to have their homes multiple listed. There are times when that does not occur. But when it doesn't occur, there is a form that the sellers have to sign attesting to that. Brokers, again, have to be very careful about their advertising. For example, I, as a realtor, can use the term realtor, and then underneath that, licensed real estate broker. I can put licensed real estate broker under my name. I can use the term agency if agency is a part of my business name. But I am not permitted to use other names. For example, I can't by itself just use the term realty or land sales, because that might be a private individual attempting to let the public feel that they're brokers when in fact they're not. They're a carpenter pretending to be a real estate broker. So because of that, there are just certain prescribed names that we can use. Realtor, realtist, real estate broker, real estate agency, they're okay. But just, we're not allowed to use other names all by themselves. Real estate brokers have websites, salespeople have websites. Always the name of the agency is there. A salesperson's website has to mention the agency they're affiliated with and have the agency's name more prominent than their own name. A lot of salespeople get carried away with their photographs and make the public think it's their office, when in fact it's not the case. And the Real Estate Commission in New Jersey wants the public to align itself with the broker and the broker's agency, not the salesperson's. In advertising, brokers can't offer the public free appraisals. Brokers can offer free CMAs, comparative market analysis, which are not as exact. You need an appraisal license to be able to say free appraisal. We can offer a free CMA. That's okay, because it's not as exact or complete as an appraisal. We're not allowed to use the word. We're not allowed to mention that the property that we're advertising is in and around a certain city. If it's in a city, we mention in our ads in the top caption and then all the listings underneath that. We can't say that the property is in and around. Sometimes brokers advertise a home inspection or a home insurance, and they have to mention in their ad who pays for it. Is it the broker? Is it the seller? Is it the buyer? So again, ads must specify the property's municipal location, specifically named in the ad. Phrases as in the vicinity are prohibited unless the embodied ad also contains the exact municipal location. If the ad mentions anything about an MLS, sometimes the broker has to mention the MLSs they belong to. And every broker is different. Some belong to one MLS. Other brokers belong to many multiples. I mean, in our neck of the woods, the Monmouth Ocean County Board of Realtors, there's Middlesex County Board of Realtors, Mercer County up around the Trenton area, up around Rutgers and Piscataway and East Brunswick and North Brunswick. You're talking about Middlesex, and up further North Jersey. There's a lot of splinter MLSs, so the broker may belong to a bunch of MLSs, and there's certain advertising that the broker has to mention all the MLSs that he belongs to, and a lot of other advertising he doesn't have to say that. For example, on a simple yard sign that they put on a lawn, brokers could just put member MLS, or a spot classified ad. A spot classified ad is an ad that's no more than 20 lines long and no more than 1 column wide, like what's in Holmes magazine. Uh, so again, any advertisement that refers to a home warranty must state whether the inspection is required, if the warranty is mandatory, and whether the purchaser is responsible. Any ads may not indiscriminately promise financing. When it comes to financing also, a broker may not say $60,000 down payment and buys this house, because there could be people that will come into his office that have the $60,000, but their credit is not good. And if the broker says, well, your credit's not good, the public can say, yeah, but your ad doesn't say that. It just says $60,000 down payment. And so that could be misrepresentation. So the broker has to always mention, when it comes to a down payment, the words "to a qualified buyer." Advertising can't indicate that the property is sold until after the closing, and the reason for that is it influences the public to think that they can't issue backup orders or offers, which the Real Estate Commission feels is, and it is in the interest of the public. And if this deal presently falls through, somebody else has a contract as the second buyer, and they can move right into place, and there's no lapse in time. So as to not discourage backup offers, the broker can't put the word "sold" when he gets the contract signed. He can put under contract or deal pending, but the word "sold" can only be put on a for sale sign after the closing. And again, obviously in advertising there can be no discrimination based on the protected classes of race, creed, color, national origin, sex, familial status. In New Jersey, you cannot price fix. Price fixing is where brokers and salespeople go to the public and say everybody charges X amount of commission. That's against price fixing laws. They can say our office gets this rate of commission because we have so many salespeople, we dominate the marketplace in this area, and for that we want to get paid. So although others offer less commission, that's fine. I'm not pointing fingers at them, but we know what we have in our office, and we really do want to get paid for it. And now let's talk about if we get in trouble, what can happen. You're going to be dealing with a lot of people, and there can be violations. Now when there's a violation, it depends on the violation. For example, sometimes a simple telephone call by an investigator of the Real Estate Commission could settle it. That's something very minor. It doesn't happen often. What happens most of the time is that that salesperson or broker is going to be invited to a full-blown hearing, and the full-blown hearing is held in Trenton. And the salesperson or broker have 10 days to prepare for the hearing, and it's held in Trenton. And they can bring their attorneys to the hearing as well. Now, based on the hearing, and the real estate commissioners are going to listen to the hearing, listen to the answers to the accused, and based on the facts as they're presented, the salesperson's license could be put on probation, or he or she could be put on probation. The Real Estate Commission can say, "Don't let this happen, and we'll put you on probation for 6 months. Don't let anything happen like this within 6 months. Otherwise, the penalties could be far more severe." What else? Well, the Real Estate Commission could suspend the license of the licensee. Now, if a license is suspended, it's suspended only till the end of the licensing period. Now, the licensing period, which you have to know for the state test, begins on July 1st and ends on June 30th biennially, every 2 years, in the odd years. For example, if you have a license this year, right now, year one would end on June 30th, 2014, okay? And it would, I apologize, that would be the end of the first year, from July 1st, 2013 until June 30th, 2014 is year one. And then it goes again from July 1st, 2014, and will expire June 30th, 2015. So it starts in 2013, and 2 years later it'll expire. So it's a 2-year license. Except for the first year, all licenses begin on July 1st and expire June 30th in odd years. So the next licensing period will start July 1st, 2015, and end June 30th, 2017, and so forth. Every 2 years, that's the way it's set up. let's talk about some of the violations. Well, anybody who makes false promises or substantial misrepresentation, that's a violation. For example, they say children are going to go to a certain school system, and after the closing, the kids go to a different school system, an inferior school system. That's misrepresentation. Saying that a house had city sewers when it has a septic system, that's an example of misrepresentation. Telling the public that they're going to sell get a contract signed before the sun goes down the very same day, guaranteed, is people are mostly misrepresenting. So there's a difference between a mistake, misrepresentation, knowing the fact to be not true, misrepresenting not knowing the fact to be true. Let's say that the salesperson did not know about city sewers and septic systems. That's one thing. But if they actually, it can be proven that they did have knowledge that there was a septic system and they were telling the buyer there was a city sewer, that's far more serious. So there's a mistake, an innocent mistake. That's, very minor. Then there's misrepresentation, not knowing the fact to be true, misrepresentation, knowing the fact to be untrue, and lastly, the worst of the lot is fraud. That's the worst of the lot. Also, the failure, of course, to account for or pay over any money belonging to others, conduct demonstrating unworthiness and incompetency, dishonesty, or bad faith. Just to give you a few. For example, if someone is asked to appear in Trenton for a hearing, or for a full-blown hearing, and that person does not go to Trenton, and doesn't show up, they would be, it would demonstrate a violation of conduct demonstrating unworthiness, incompetency, dishonesty, or bad faith. So there's 20 ways in which we can have our licenses suspended or revoked. And obviously you want to make sure you read your text to see. For example, one of the violations is if a broker uses an insignia, a logo, on his stationery or business cards of an organization of which he's not a member, that's a violation. If we don't give a copy to the public of what they signed, that's a violation. And we can't change their copy or ours, they have to be the same. What they have signed and what we have, we can't act as a dual agent without permission to act as a dual agent by both sides in the real estate transaction. We can't procure a real estate license by fraud or deceit. We can't commingle the licensee's own money with the clients. We can't sell property in which we have an interest without letting the public know we have an interest in that property. This gives you an idea of some of the violations that we can have trouble with. So I'm going to turn back to your key terms in your textbook and take a look and make sure that we've covered some of these key terms, because maybe I didn't mention it. For example, right off the bat, I see the word branch office. Now, all real estate brokers have a main place of business, but that broker may have several offices, what they call branch offices. There is only one broker of record. That's the person who owns the agency or the person named in a corporation. His name is outside of all the branch offices. When you go to any branch office of a broker, if he has 6 offices, outside you'll see only one name, the person who owns the company. However, the person managing the agency could be a broker salesperson. Years ago, you just had to be a salesperson that had 3 years or more full-time experience. You can manage a branch office. Today, that's not the case. Anybody managing a branch office has to be a real estate broker. All right. We mentioned the term. So real estate brokers can have one office. Some have 3 offices. Some brokers, by the way, buy into franchises. Now, there's no secret. You have Century 21, you have Weichert, you have Coldwell Banker, you have ERA, you have Heritage House with Sotheby's. There's a whole bunch of companies that are part of a franchise, and brokers pay in. But as far as a franchise is concerned, they have to mention each office independently owned and operated if they buy into a franchise, because they don't want the public to think it's a major organization when it might be an office with 6 salespeople where the broker paid $30,000 to buy into a franchise. So it's misrepresenting the public, and that's why certain advertising, they don't have to say each office independently owned and operated. And other types of advertising, they do have to say that. Now I'm looking at the key terms in your textbook. Branch office. Commingling, we talked about. What is that? Mixing money that belongs in the personal account, in the trust account, vice versa. Escrow account and trust account are one and the same. Guilty knowledge. Well, when you get a test question, who is ultimately responsible for the deeds of an agency? The answer that they're looking for is the broker of record, because it trickles down. I mean, it may be in a branch office, he's got 20 offices, but maybe he didn't train the manager of that office well. And maybe it's a salesperson who gets in trouble, but it could trickle up to the broker because the manager didn't train the salesperson right, but the broker of record hired the manager and didn't train it. So the buck stops on the desk of the broker. Okay, so when you get a test question, who is ultimately responsible for the deeds of an agency? Now, you also can get a test question about guilty knowledge. If the broker has no guilty knowledge of a salesperson doing anything against the law, his license is fine. It's not going to be jeopardized. If he did have guilty knowledge of what was going on and it was wrong, yeah, his license could also be. I don't see any of these key terms that we didn't talk about. Branch office commingling, duplicate of the original, escrow account, guilty knowledge. And then on the other side in the key terms, probation, revocation, suspension, trust account, and waiver of broker participation fees. So I would think that we would have covered chapters 1 and 2. So maybe what we can do is we can push that button and